The Constitutional Court has declared a section of the Electoral Act as unconstitutional, and this paves the way for independent candidates to contest provincial as well as national elections. But until now, only political parties were allowed to do so.
It is declared that the Electoral Act 73 of 1998 is unconstitutional to the extent that it requires that adult citizens may be elected to the National Assembly and provincial legislatures only through their membership of political parties. 5. The declaration of unconstitutionality is prospective with effect from the date of this order, but its operation is suspended for 24 months to afford Parliament an opportunity to remedy the defect giving rise to the unconstitutionality. 6. The Minister of Home Affairs must pay the applicant's costs in the High Court and this court, such costs to include the costs of two counsel. I hand down the judgment.
The ruling has been welcomed as a win for democracy and accountability.
Africans has been given some of the weakest and the most corrupt leaders up to this point. And for that reason, this is critical, that democracy ultimately wins. Because now, finally, individuals in this country will have an opportunity to stand and to keep those that they have elected accountable. These guys that we currently have in Parliament and in political offices all across the land, these guys are simply a law unto themselves. They are not accountable to the people, and this is what this judgment does. It brings accountability back, and it gives democracy, the heads up. We will never be, under the mess that we are currently in. Finally, we have an opportunity to rid South Africa of incompetence and corruption.
In other words, when you vote for a party, you don't necessarily have the power to, when a party appoints or elects someone to be in the National Assembly, you may like the principles of the party but not necessarily the person. But when you choose an independent person, that person is working for, so because the next time, if he's not doing what you as elected him for to do, you're not going to elect him again. So people will, in other words, instead of going what a party tells you to do, you will hopefully look after the people that voted for you. So those principles are important to you, and there comes the accountability. So it's hopefully it will allow for people to vote for someone that stands for exactly the same principles, but will also look after their rights.
Well, one South Africa movement leader, Mmusi Maimane, has welcomed the judgment, and he says this will help change the country's political landscape.
It sets on course democracy for South Africa. It restores the very value that says it's always by the people and for the people. It deals a decisive blow to state capture, because state capture emanates from party capture. It's when people capture the party and then they capture the state and then they vote unanimously on whatever they want. And ultimately, it gives accountability back to communities. So to me, I welcome the judgment. We fought hard as One South Africa movement and New Nation movement have led the process to say we want to see electoral reform. And this begins a 24-month journey upon which ultimately adults in this country who are not criminals, who represent their communities, can finally be able to stand up for public office without following the traditional party route and say accountability is to the people and they can serve citizens in their community.
So let's give you analysis then and insights for more reaction on that judgment about the Electoral Act. We have a panel of two. That's Lawson Naidoo, who is Executive Secretary at the Council for the Advancement of the South African Constitution. That's CASAC. And Owen Mokoena is Senior Legal Researcher at the Land and Agriculture Development Bank of South Africa. He also taught me constitutional law. So if I am great, it's credit to him. If I am terrible, it's all about me. Thank you, gentlemen, for joining us this afternoon. So let me start with you, Lawson. Your reaction to this judgment, how significant is it?
Good afternoon to Lesizwe. This is, undoubtedly a groundbreaking judgment. It's going to have an impact, on our constitutional foundations, that are very far-reaching. We are now forced, Parliament is going to be forced to change the electoral system. The electoral system that we've been using at national and provincial level since 1994 is now going to have to be changed, probably with effect from the next elections in 2024, to make provision for individual candidates to contest those national and provincial elections. Up until now, the right to participate in those elections was limited to people who, through political parties, you had to be on the list of a political party in order to qualify for election to a national or provincial legislature. So it's a significant judgment, but I think it's important to note that Parliament has been given 24 months to determine the most appropriate electoral system for the country, and I believe that that is the correct thing to do, because the Constitutional Court can correctly, as it did today, determine whether an Act of Parliament is constitutional or not. But the question of an electoral system for the country is primarily a political decision that is best left to Parliament and not a legal one, and I think the Court did well not to try and circumscribe the kind of electoral system that we ought to have.
And Owen, how far-reaching do you think this is? Is it merely about tweaking the sections of the Electoral Act and thereby providing for individuals to stand for election at provincial and national legislature level, or is it, as Lawson is saying, that it will be far-going and systemic in terms of the changes that it brings?
Yeah, it goes without saying that the reason the court gave Parliament really 24 months to give them enough time to come up with a system, because as you know, currently our electoral system is based on a party list, or what we call proportional representation. And now, given that we're introducing independent candidates, that means that we probably have to then have a constituency-based system, or we're probably going to have a hybrid system as well that encompasses both the proportional representation and constituency-based as well. And as you will know, this is already done at the local municipality elections, where you vote for the party, but you also vote for your ward council, who will then represent you as your councillor. So it will be interesting to see as to what type of system that Parliament comes with, whether it will be constituency-based or it will be a hybrid. And if it's going to be a hybrid, it will require really a lot of work to amend the Electoral Act to enable the citizens to be able to now to vote for both parties and for independent candidates as well.
And Owen, it came down to the whole talk around Section 19 of the Constitution, which gives rise to those political rights to be able to, form and join a political party, campaign for a political party or a cause, and also to stand and be elected to hold political office. It always struck me as strange that this was happening at local government level, as you point out, that you could stand as an individual at local government level, but you couldn't do so at the level of the provincial legislature and the national legislature. To you, was there any doubt that this would be the outcome?
Not necessarily. So even though the first judgment, as you know, the history of this matter started in the Western Cape High Court. But the constitutional framework needs to be looked into holistically, because the founding provisions of the Constitution, which is Section 1, speaks about a government based on a multi-party. And if you look at then Section 19 at the beginning, it talks about includes, which will mean that it's not limited, but again, it focuses on political party. Then Section 19.3 then talks about standing for public office, but it does not dictate. And if you go further to look into the whole scheme again, where it gives Parliament powers to dictate as to how the Electoral Act should be, Parliament then has decided that for both provincial and for national, they will not have independent candidates, but parties. And the Constitutional Court was correct to say today that even that Section 19.3 gives that right to say you must hold public office. The Constitution does not dictate to say it must be independent candidates or parties, but then it allows now to have both.
And Lawson, talk to me about this idea of accountability versus, party line and discipline. We saw it at play in the last few years of the Zuma presidency, where, there were all these debates about whether or not people are being loyal to their oath of office as far as being members of parliament is concerned and the constitution, or were they being loyal to their political parties. Having independent members of parliament and provincial legislatures, how game-changing would it be then for accountability?
To this way, I think we need to look at the experience at a local government level, because at that level we have examples of ward councillors where independent candidates can stand. It sadly has not resulted in any greater levels of accountability at the level of local government. So I think any change to the electoral system must be clearly and properly designed to take heed of the need for greater accountability. And in that regard, we can't, exclude the institution of Parliament needing to change some of its ways and operations in order to ensure greater accountability. So whatever mechanism we use to elect people, ultimately, Parliament as a body is the institution that needs to exercise that power on our behalf. And I think, if we look at examples from around the world that have whether constituency systems or hybrid systems, there's no single way in which political accountability is extracted. It really depends on changing the political culture within a society. Even with this change in the electoral system, it's not going to overnight change the power of political parties. Political parties are foundational to the political system in South Africa. They will continue to be with us for a very long time. So I think we need to bear that in mind. If I can just add one other thing to Lasizwe, it's that the injunction in the Constitution in Section 46 that says that any electoral system that we choose must result in proportional representation would appear to exclude the possibility of a simple first-past-the-post constituency system.
Yeah, so this sets us on a path likely, and we're in the realm of speculation, of course, and there's 24 months to go before Parliament can actually sort that one out. But we can safely start talking about the possibility of a hybrid system that's similar to what we have at local government level.
I would agree with that. And, as we know, that was the recommendation from the Frederick Frenzel Slabbert report in the early 2000s, which regrettably Parliament has failed to engage with for nearly 20 years. And I think, we've been lobbying for a long time that we need to review that report to engage in a public debate about the kind of electoral system we have. And I think, for me, those are some of the options that we will need to look at. And it's really a question of how we construct that hybrid system to make it suitable for South Africa and to ensure that the system that we put in place does, in fact, enhance accountability.
Owen, let me bring you back in. Talk to me about, is there some kind of a revolution happening right before our eyes in as far as, how politics plays out, how electoral politics plays out? What do I mean by that? This judgment today, but also recently you had the president signing into law the Political Party Funding Act, and that coming into operation, and also recently aspects that have to do with promotion of access to information about political party funding. Is there a revolution of some sorts happening, and is this the right kind of revolution that we need in as far as our scheme is concerned, our constitutional scheme is concerned?
Yes, I wouldn't go as far as to call it a revolution, so to speak, but I think today's judgment just shows us how democracy evolves. Democracy is not stagnant. We're going to see quite a number of changes as we continuously progress to make sure that our democracy works better for us. As Lawson has already said, that we shouldn't be quick to celebrate, to say that a hybrid system will bring about accountability. You've got systems such as in the United States, where you have independent candidates, and the Westminster system as well, where you've got independent candidates as well. And when it comes to accountability or getting legislation passed through, when it's based on constituency, you find people then really struggling at times as to whether what their parties need, or should they be focusing on what their constituency needs, and to see what system we eventually end up with, whether will it be constituency based or will it be a hybrid system that still has the party list and again the independent candidates as well.
All right, Owen, your line is not so great. Let me give Lawson the last word then. And it's a bit of a trivia question on my side. On paper then, Lawson, it would seem that it's possible, it would be possible after 24 months that we could have an independent who doesn't belong to any political party being elected at the first sitting of Parliament to be President of the Republic.
Well, the system of electing the president doesn't change in terms of this judgment, Tula Sizwe. Any member of the National Assembly is eligible to stand as a candidate for election as president. So if an independent candidate were to make it and be elected as a member of the National Assembly, they would be eligible to stand for office for president, and if elected by those members of the National Assembly, could become president.
Yeah, no, I guess I'm talking about the possibility of many independent candidates and independent members of parliament then deciding that, hey, we're going to go with one of our own. But that's really in the realm of trivia on my side. Lawson Naidoo, thank you so much for your time this afternoon. He is Executive Secretary at KSEC, and Owen Mokoena, who is a Senior Legal Researcher.